Second question, what do these actions mean? Why isn't this all just a lot of bureaucratic detail? First, let's state what the rules of the game are, rules that you have all been trained in and repeatedly trained in, but your public is perhaps less familiar with. The Brown Act requires all council discussions involving more than two of you, even if it's email, to be done in public. There's a good reason for that. If you have lots of discussions outside the public's eye and come into open session, the open session becomes meaningless. It becomes some sort of a public drama where all the decisions were made and you put something up for show so the public can think they're participating in their government but not actually do it. The law requires you to have the self-discipline and the integrity to talk to only one other member about any city business except in this room where the public can watch. The government code is not written in a way that lay people can't understand about closed session competences. Government Code Section 54963, a provision of the Brown Act that you can read on most of the blogs in your city because of Councilmember Tam's conduct, says, a person may not disclose confidential information that has been acquired by being present in a closed session to a person not entitled to receive it, unless the legislative body authorizes disclosure of that confidential information. Did this city council authorize release of this information? Of course you didn't. She broke the law. It couldn't be more plain. Keeping secrets is pretty basic. I think we all learned on the playground in elementary school that telling secrets we agreed to keep is just wrong. Government is supposed to be even-handed, especially when it comes to openness in government, what the city's advisory committee calls government in the sunshine. Providing information to your favorites and your political allies that the city is required legally to keep from everyone is not even-handed government. It is not acting with integrity. City leaders are supposed to protect the taxpayer. They're not supposed to aid those who are negotiating for city money who are suing the city. Again, this is something else we learned in elementary school. It is simply wrong to help the other team in an honest competition. It's an abuse of power to try to fire those who work for you because they will not get out of your way when you want to break the rules. If staff gets out of the way, does the easy thing rather than the right thing, they'll probably work for you longer. But that kind of self-protective behavior invites corruption and cronyism, and it allows elected council members to interfere with the administration of the city. You don't get to do that. Under the council manager form of government that your voters chose in your charter, you set policy, non-elected, non-political professionals manage staff. These lessons about protecting the integrity of city administration from political influences were learned long ago with great pain and great expense in places like Cook County, Illinois, and Tammany Hall, New York. That's why California's progressive movement gave us the council manager form of government. That's why your voters adopted a charter that includes it. Now, your charter doesn't include a provision to allow you to oust somebody from office. Because it doesn't, you have to look to the government code. And the government code says the grand jury does it for you. The district attorney is a gatekeeper for the grand jury, and for reasons that puzzle me, she's barred that gate to justice for you. The Fair Political Practices Commission has no authority to enforce the Brown Act or fiduciary duties. They enforce the campaign finance laws, and they enforce the Political Reform Act regarding economic conflicts of interest. We don't know that Councilmember Tam made any money from this misconduct, and we never charged that she did. We don't have the tools to investigate whether that happened, and for her sake and for this community, I hope to God that that didn't happen. You're all trained early and often to avoid violations of the Brown Act by not talking to two other council members in email or otherwise. By secretly copying Councilmember Gilmore in emails to other council members, Councilmember Tam involved you in Brown Act violations that only she and Councilmember Gilmore knew about. This was a breach of trust, making it hard for you to accept emails from her in the future. You're now in the position that when you get an email from Lena Tam, you have to say, geez, can I open this? Can I reply to it? Do I have to make a note for a ledger in case some investigator comes to know about my participation in a Brown Act that I'm covered? That isn't conducive to the kind of government that any community wants for itself. Let's turn to my next question. Why do these actions matter? What's this all about? First, Councilmember Tam violated the oath she took when she was sworn into office to uphold the law and the California Constitution because she violated her duties to protect the city's secrets. She violated her duty to comply with the Brown Act by not engaging in conversations with 2 or more council members about city business outside an official meeting, and she failed to comply with the charter by not resisting the temptation to interfere with the city manager's management of the city. Number 2, she gave special treatment to SunCal, the firefighters, and other political favorites, violating that basic principle that the government of the people, by the people, and for the people should be even-handed for all people. 3, she aided and abetted those negotiating with and suing the city, selling out the taxpayers for private interests. Pretty basic stuff. These are not rules you need a law degree to understand. We all picked them up on the playground. 4, she tried to fire the city manager, the city attorney, and the fire chief. Who would work for a city where you can get fired if you get in the ray of a political steamroller because you're trying to do your job to protect the city's legal and business interests? What kind of government can Alamedans expect if this is allowed to happen? 5th, she undermined the city manager's ability to manage the city and the fire department and fire chief in particular. Her conduct leads a reasonable person to ask, who's running our fire department? The city manager and the fire chief, or the firefighters union? Who's looking out for the taxpayer? Will they be fired if they look out for the taxpayer? 6, she violated the trust of all but one of her fellow council members, making it hard for them to trust her or to work with her. Last question. What, if anything, can the city do about this? First, certainly you can do nothing and let the voters sort this out on November 2nd. This may indeed be the only way to resolve this once and for all. But the city cannot allow the council to believe, as Ms. Tam said yet again tonight, that she's been cleared by a vigorous investigation by the DA. There was no investigation by the DA. The DA read my letters and decided, for reasons that escape me, not to do justice in this case. Councilmember Tam doesn't deny sending these emails. She told you tonight she's going to do it again. She said everybody does it. I'll keep doing it. It's how I protect the people who elected me. It's not, Councilmember Tam. It's not the right thing. Her claim she was doing due diligence is simply not believable. Using this legal and bureaucratic jargon, probably supplied by her $900 an hour criminal defense attorney, cannot obscure the fact that she gave the city's secrets away. She doesn't deny doing it, and she apparently thinks she did nothing wrong. Who can blame us for expecting her to keep doing it? Thus, neither city staff nor most council members trust her with city secrets, and the city has held no closed sessions on any legal matter since the investigation became public in July. So if we do nothing, we live with this burden so long as she remains in public office. Second, you could sue her. I don't recommend it. The upside of a lawsuit is that we would very likely get a court order telling her to do what the law already requires her to do. Protect your secrets, don't do illegal and favoritism acts. She ignored the law already. What more will we get from a judge's order telling her to do what she should already do? And lawsuits are expensive and take time. While we would get the benefit of the judge being willing to enforce his orders, and we would get the penalties of contempt of court if she violated such an order, we would get justice the district attorney is not giving us. In my judgment, it's too expensive and takes too much time. Thirdly, you could censure her. You could adopt a resolution formally disapproving of her misconduct. However, that will require that she get notice of the action and an opportunity to be heard on it. That would probably be a political circus. I doubt that that circus would be helpful in the effort to defend good government in Alameda and indeed everywhere. But whether you think such a resolution would be useful is your judgment, not mine. We can and we will continue trying to persuade the district attorney to do justice here. We never got to see her respond to Mr. Kecker's August 12th letter rebutting mine. The fact that there's a letter from her very talented Yale-educated lawyer that never got responded to or rebutted by our side of the case may explain the district attorney's error. But I do want to make clear the district attorney did get it wrong. She swallowed whole an argument from Mr. Kecker that is simply wrong. As I said, the Alameda Charter provides no process for removing a council member for misconduct, although they do lose their office if a court convicts them of a felony. Thus, the remedy for Ms. Tam's misconduct, because no felony has been proven, is a civil lawsuit under Government Code Section 3060, which only the DA can bring and only after the grand jury requests it. Ms. O'Malley is refusing to allow the grand jury to even look at the evidence. She's claiming that the case of Steiner versus Superior Court prevents her from doing so. With all due respect to your recently elected district attorney, this is simply wrong. Let's talk about Steiner. In Steiner, the Orange County grand jury tried to remove 2 Orange County supervisors from office for failing to prevent the county treasurer from making risky investments that ultimately bankrupted the county. The court concluded that Government Code Section 3060 doesn't allow a court to remove a legislator from office for failing to take legislative action. Under our system of government, legislatures decide what laws to make, and courts apply them. Courts do not require legislatures to adopt laws. This is called the separation of powers among our judicial, legislative, executive branches of government, as we used to teach in civics. This is not what happened here. We do not seek to hold Ms. Tam responsible for laws she did not propose or laws she did not vote for. We seek to hold her responsible for plain, repeated, and inexcusable violations of her duties to keep the city's secrets, to comply with the Brown Act, not to help those suing the city, not to violate the charter by politically interfering in city administration. Thus, we have asked for a copy of Mr. Kecker's August 12th letter. We intend to reply to it and hope the DA will reconsider.
So I hate to interrupt you, but could you wrap up shortly?
Yes.
Okay.
In conclusion, next topic. This is not a happy day for Alameda or for anybody who cares about good government. The responsibility to hold Ms. Tam accountable for her misconduct and to make clear that similar conduct cannot be tolerated from her or others in the future is not a pleasant task that any of us ask to take on. I have genuine sympathy for people who place their trust in Ms. Tam, her friends and her supporters, and the people in her community that look to her for leadership. It is painful and hard to accept that people we cared for, people we worked for, people we trusted, and people we voted for did something wrong. But she did. Unfortunately, our duty to hold her accountable and to fight for integrity in government is not a duty we can shirk. If not us, who? If not now, when? I'd be happy to answer any questions you might have.
Okay.